Hi, this is Greg McIntyre with McIntyre Elder Law, and this is the Elder Law Report. I'm here with fellow attorney in our firm, Therron Causey, and we're going to talk about out-of-state documents. We've got a lot of people moving into this state. We have offices in Charlotte, Shelby, and Hendersonville, and I know especially in Hendersonville and Charlotte, Mecklenburg County, it seems like 2/3 of the county has moved in recently from out of state,
Sure.
right? So some people come to us and they have their estate planning documents and they're really curious. They might need some changes or want some things done. They might want to update, and there's reasons why you would want to review every few years, or every once in a while if you have major life changes or if the law changes, and you need to know that. I think also moving in state, you want to look at the advantages that state has under their law that might benefit you. So that's a need that I always recognize, to review your current estate plan under the prior state laws. But Therron, question I get all the time is, will my out-of-state estate planning documents be honored here? What's the answer?
Well, the answer is, it depends, right? I would say that for a large majority of those documents, they will be honored. The full faith and credit clause of the Constitution ensures that the respective documents from the surrounding states, amongst the states, will be honored amongst the states, right? Now, beyond that, there are some further requirements. Right? The further requirements might include considering the statutory requirements on execution of those documents, whether one state has a lesser requirement than, say, the new state, right, the host state. There are all sorts of considerations, and I know you've named a few, that we take into account when we're considering out-of-state documents. I'd say as a general rule, the answer is, to the question of whether they're valid, is generally yes, they are. But we want to make sure that
legally they are,
correct.
But practically is where I always have such a problem.
That's right.
And explain to clients or see clients have big problems.
That's right.
So practically, good luck taking a California power of attorney to a North Carolina local bank branch.
Exactly.
And the teller looking at it and knowing what they're looking at.
That's right.
Those banks aren't used to dealing with those California power of attorneys.
What's the
so it's going to make
law?
It hard to use. What's the governing law? They're not going to know.
Right.
It's a great question. Yeah.
And you bring up a good point, because powers of attorney, when they're relied upon, it's almost always in some sort of reactive stance, right? Something has happened, we need to take action, we are authorized and empowered to do so.
And we need to do it now.
That's right. And so we don't want to take our document to the bank, have the bank say, let us have our legal team look at it, and then wait 3 days before we get a response back to you.
And we were talking about this earlier today too. I mean, my mission for our clients, for our firm's clients, my goal is to give them the best possible experience. That's what they pay us for. To look at these pitfalls and help them avoid them. That's why I want to record the powers of attorney coming off the closing table at the Registry of Deeds for our clients.
Exactly.
Right? I mean, because when they need to use them, you bring up a great point. They need to use them. Their agent needs to be able to do things when they need, and doesn't need, everybody needs to press pause for a couple of weeks or a month while the bank figures this out.
That's right.
Or sorts this out, or it's not recorded, so you got to deal with trying to figure out what the Register of Deeds is, going there and recording the document.
And it doesn't just stop with a power of attorney either, right? I mean, we've got the estate planning in large and probate especially. These laws vary amongst the states, especially when you're talking about trusts, Uniform Trust Code, and the various probate laws in amongst the states. So there's all kinds of things to consider. When I'm looking at somebody's existing estate planning work, I have an eye on all those things. And really the application of, if I ever need to use these, what does that really look like when it's time to apply right? When rubber meets road, what are we looking at, and what is the experience for the client going to look like?
Right.
And we want to be able to identify those and see that, have that
Yeah.
court vision to see that down the road.
That's right. That's right. So, and the reason I have that court vision is because I've experienced those problems with clients and had to fix them.
Yeah.
Or walk them through how to fix them.
That's right.
And wills, you mentioned, trust wills. I mean, take an Alaska will when somebody dies to a North Carolina court. What's the governing law?
Sure.
Technically, I mean, you're supposed to probate that under Alaska law, right? In North Carolina. And that's always my question and debate is, okay, what law are we using here? And is a clerk at the courthouse going to know that?
Right.
And they're used to checking, like laying a template on it for, are there two witnesses
The rules
and a
of
notary?
construction, right?
Right, the rules of construction in North Carolina.
And execution.
Right, and execution of the documents, signing of the documents. Are there two witnesses? Are there a notary? Was there a notary? Is there a self-proving affidavit? Is there self-proving, if it's not labeled that way,
right.
Is there self-proving language in the witness block and the notary block that allows for us to not have to, or the executor, if we're involved, to not have to go get affidavits signed,
That's right.
track down the witnesses that saw the signature. I mean, does that apply? Is Alaska law the same?
That's right.
And should we judge this will in North Carolina under what the requirements are in Alaska, right?
And that's a valid concern
Yeah.
that we as attorneys, we're not going to have a pulse on every state's nuance in their laws about this, the
They're all
construction
different.
or the execution. And so we want to know that what they have is going to work when it needs to work.
I'm getting licensed in all 50 states. I'm taking 49 more bars.
And the question then becomes, if I've looked at this, is this going to manifest at some point into some sort of ineffective document?
Right.
Am I going to go to try to probate it and, like you said, have to chase down two witnesses or a notary from 1993?
Right.
Is that even possible?
That may have happened to be at a bank that day when you stopped by to have it signed or whatever.
What kind of effect would that have on the disposition of my estate?
Right.
If I'm saying these are the people that I would want to leave my property to, and then it comes
You're
to
certainly
find out,
not making it easy on your heirs.
No,
and the
not at
exec.
all. And the will becomes invalid, and then the whole plan is just set aside, and that can have a real impact. Especially for families and for folks looking to preserve and pass on that legacy.
Agreed. So for your sake and the sake of everybody, of your agent and a power of attorney, the person you're appointing to help you, your executor and your will, your heirs, and we haven't even talked about trust and trust administration, because that's a whole other can of worms about where the situs of the trust is located, which could be any state. You could take advantage of favorable state income tax rules or states that don't have income tax by changing the situs of the trust. You can do that. All of those things are things that need to be evaluated, reviewed, and contemplated, especially if you're moving to North Carolina and you've moved to North Carolina and you brought with you an estate plan. And I think for the sake of your heirs, executor, trustees, beneficiaries, and your agents appointed under a power of attorney for financial and health care, and for yourself, I mean, you're really looking to make your life easier during your life, and then make your family's life easier and enrich it if you were to pass away. So that's why you do. And I counsel my clients that move out of state from North Carolina. I want you to see somebody like me. And I want you to see us. We would be glad to offer a free review of your current estate plan and go through that, point out how North Carolina law is different, maybe, and where we see potential problems, both legally and practically. we'd offer that free consult and review. You can take advantage of that by simply going to our website, mcelderlaw.com. You can schedule your free consult right on our website, or you can call us at 1-888-999-6600. I look forward to sitting down with you soon.
Please don't wait till it's too late. Call McIntyre Elder Law.